afternoon. My name is Anupam Chandler. On behalf of Chris Ribetto and myself, I'd like to welcome you to another in our series on surveillance democracies. I want to thank two people who have made this all possible. Lynn Lay, our post-doc fellow, who is probably running around making sure everything is okay, and Nina Bell, who is assuredly doing so. Thank you to both of you. So, seen in a narrow light, Apple has been waging a battle to protect the privacy of alleged terrorists. But in a broader sense, Apple is seeking to protect the security and privacy of all of us, users like ordinary kids in California to dissidents in Russia. And I think in that context, we can understand better Shane KADIDAL's life work. Shane KADIDAL is a senior managing attorney at the Center for Constitutional Rights, where he has worked on several significant cases in the wake of 9/11, including the Center's challenges to indefinite detention at Guantanamo and also domestic immigration cases. He's been counsel in major cases, including Holder v. Humanitarian Law Project, an infamous case from my perspective, to a number of important cases, including USA and Vulcan Society v. City of New York, and legal challenges to the NSA's warrantless surveillance program. He currently serves as U.S. counsel to WikiLeaks publisher Julian Assange in connection with potential Espionage Act charges, extradition, and also the funding embargo. He led litigation on behalf of several journalists that resulted in the public release of hundreds of previously withheld documents during the court-martial of Chelsea Manning. He's a graduate of Yale Law School and Duke University. He is a former clerk to Judge Kermit Lopez of the U.S. Court of Appeals for the First Circuit. It's my delight to welcome Shane KADIDAL.
Thank you, Anupam, for that kind introduction. I think that's the first time I've ever been introduced with reference to my undergrad degree from one of America's top schools. So, thank you for that.
I see it's hidden on your
It was well hidden, thanks. So my goal here is to give you a little bit of a broad overview of how we think surveillance practices really haven't changed since 9/11, and really how the legal landscape isn't doing much, either from Congress or the courts, to force change in that kind of continuity of mass surveillance practices. That's the short version of the next hour's talk here. But I wanted to kind of start by essentially kind of asking really what has changed since Snowden's revelations. Right? It's been this summer it'll be 3 years since Edward Snowden's disclosures revealed the massive scope of our government's bulk surveillance of global telecommunications. And the very first document of that Snowden trove to be published, both by The Guardian and The Washington Post, showed that the secretive Foreign Intelligence Surveillance Court ordered Verizon to turn over logs of all phone calls made to and from its customers. And of the many documents that followed, and the many bulk surveillance programs that were revealed by those documents, I think this phone records program has continued to attract the most attention, in part because its features seem tailor-made to be challenged in court. And in fact, it was challenged several times in court right afterwards. Right? The features were that it involved surveillance of everybody in a very well-defined category of American customers, namely customers of essentially Verizon Wireless, under an identified statutory authority, Section 215 of the Patriot Act, that allows the government to essentially get a court order from the FISA court and use that order to demand business records of a whole variety of businesses, including telecom providers. And those two features made it pretty easy to presumably find somebody who would have legal standing to challenge this assertion of authority, and anybody who's a customer of Verizon, essentially, or calls a customer of Verizon, and a pretty well-defined set of rules for deciding whether or not surveillance was legal, in terms of the statute. Did Congress intend with this post 9/11 statute to allow massive surveillance of, or access to phone records, right? So two of those challenges were brought, one by a libertarian, relatively conservative group, Clayman, and another by the ACLU in New York, and they were both successful, one at the trial level in DC and the other at the Court of Appeals in the Second Circuit. And those successes, I think, provoked, after several years of vigorous debate, a piece of reform legislation. Last summer's USA Freedom Act, which shut down the phone records program basically in November of last year. And so anybody who watched the Republican presidential debates, especially from about round 3 onwards, could be excused for thinking that very significant changes to post 9/11 electronic surveillance practices have happened, thanks to the work of Congress and to some extent the intervention of the courts. But I want to ask a little skeptically, has anything really changed as a result of these court challenges and changes in the law? And I would argue that we really have very little reason for comfort. That the bulk collection of metadata, like our phone records, by the NSA probably still occurs. The government very clearly has ready access to such records, even if it sits in the custody of private parties like telecommunications companies. The bulk collection of the content of our communications, not just the metadata, the data about our communications, like which phone numbers we call, but the actual contents of those communications, is more or less unaffected and has been consistently going on a very broad scale throughout the entire post 9/11 era. And that the main impact of this USA Freedom Act actually may have been to forestall review reaching the Supreme Court, review which may have given us a lot more protection in the long run, at least on the metadata front. So to explain why, I have to step back and give you a little bit of the history of this litigation, which will overlap a lot with my involvement with it, so sorry for that. But I want to step back to December of 2005, which is when most of us probably first heard of the NSA. And that was when James Rise and Eric Liplau of the New York Times published a story which the Times editors had made them sit on for over 2 years, past the presidential election in 2004. And the story's headline was essentially, the headline item was that the NSA had been collecting large quantities of calls and emails without getting approval from a court first, which is the usual process that would happen with any wiretap warrant and was actually mandated by a post-Watergate era statute called FISA, the Foreign Intelligence Surveillance Act. The Times broke the story again in December 2005, and what the story said was that since right after 9/11, the NSA had been intercepting calls and emails that had one end outside of the United States and one end inside of the United States, where they thought that one party was somehow affiliated with terrorism. But they were doing it without warrants and without getting any judicial review whatsoever, right? And so the crazy thing about this was that it seemed like this was exactly the sort of surveillance that FISA statute was set up in 1978 to allow for, right? Anyone who's thought to have anyone for whom there is probable cause to think they're an agent of a foreign power, which means any level of involvement with a terrorist organization, very broadly defined, could be the subject of a FISA order, essentially a warrant from the Foreign Intelligence Surveillance Court that allows interception of their communications, right? So the question was, this statute, which had proved very easy for the government to use since 1978, between the time of the Rise story in 1978, I think about 19,000 FISA applications had been made, and only 5 of them had been rejected by this very secret court, right? So the question we wondered at the outset was, why would they route around a statute that seemed so easy to use, so permissive, right? Our main suspicion was that they were trying to eavesdrop on communications that even a very compliant FISA judge, operating in secret without an opposing party, without any media scrutiny because its proceedings are all top secret and all sealed, that even a very compliant FISA judge wouldn't approve of. For instance, communications with lawyers with their clients or journalists with their sources. And as people who are already very busy litigating national security cases against the federal government, this was a particular concern to us lawyers at CCR, right? Because the description of the program, one end of the call outside of the United States, one person on the line somehow suspected of whatever tangential involvement with terrorism, seemed to fit a lot of people that we represented, right? So we represented torture rendition victim Mayor Harrar, a Canadian national, who was stopped on his way home at JFK Airport and then rendered not to the country with citizenship Canada, but sent to Syria, where he'd been born, to be tortured for a year at the behest of the United States, asked the same questions he was asked at JFK, right? He lived in Canada at the time this story broke, and we realized, gee, we email him and talk to him over the phone about his case, The government still claims that there was a reason to render him to Syria. You know, it seems like this NSA program is tailor-made to spy on our communications with our client. Likewise, all the families of the Guantanamo detainees that we represent located overseas said to be family members of people the government claims had a link to Al-Qaeda, right? You know, so our feeling was that suddenly all of our communications internationally related to this litigation against the government were somehow vulnerable, and that we would have to take countermeasures. You know, that for people like Arar, we would have to go fly and meet him in Calgary rather than email him, right? Those kind of things. That there was a chilling effect that this cast on our communication practices, which hindered our ability to litigate cases against the government, and that was a real legal injury, which should be enough to provide us standing. An injury that allows us to set foot in court and challenge the legality of the underlying surveillance, right? So we brought a case against the NSA, and on the same day the ACLU brought a case in Detroit challenging this warrantless surveillance program that routed around FISA, right? Now, all the news coverage of this program, right? The program itself seems on its face somewhat targeted, right? Somewhat limited. Not the kind of massive bulk surveillance of everything moving through Microsoft servers or Gmail, right? That we read about with Snowden, right? But you know, all of the news coverage and a whole bunch of follow-up stories that were based on talking to NSA sources, just off the record, also indicated that there was a data mining component to the program. And what does that mean? Basically, it's the idea that the NSA was intercepting calls and emails not in a targeted fashion, but in a general fashion, and dumping all that data into a sort of massive pool of data, and then scanning through it. So for instance, you can imagine if you have a huge database of all the email that's sent from people in and out of the United States, you can do word searches, right, the way your spam filter does, and start pulling up things that have references to Hamas or Al-Qaeda or who knows what, right? Or, you know, there may be other ways of searching through a database like that, right? If you're recording all the contents of phone calls and all the metadata, you know, the who called who at what time and so forth about phone communications, well, maybe you can apply algorithms to try to pick out from that mass of data things that might be suspect, right? So if somebody in the US gets a call from Afghanistan at 2 in the morning, in the middle of the night, and then that person calls 10 people within the next hour, again in the middle of the night, maybe that's a suspicious pattern of behavior, right? Maybe that's the sleeper cell being triggered, right? Or maybe it's somebody receiving news that some cousin got engaged in Afghanistan and spreading it to all their relatives, you know, very, very quickly, right? So you can imagine these kind of the dream of kind of, you know, creating algorithms like this that can pick suspects out of thin air without any real human involvement. Makes it appealing to have a massive database like that, right? So even early on, even in the rise of Linkblau story and the follow-up reporting, there was this implication that there was more to it than just a targeted program, right? Eventually, a case was filed for damages against AT&T based on some whistleblower documents that came from an AT&T employee named Mark Klein, who described a secret room that existed in their main San Francisco switching station where only one employee and one person who seemed to be working for the NSA and was always lost in the hallways needing guidance back to the room or to the bathrooms could enter, right? And based on wiring diagrams, it seemed like there was a pretty good chance that what was happening in this room was that every copy of electronic communications, both the internet and phone, which mostly moves digitally nowadays, was being sort of split, and one copy was being sent off to Fort Meade, where the NSA's computers are, and the other copy was sort of going on its merry way to the intended recipients, right? So that complaint alleged that AT&T was doing something that would clearly facilitate the creation of a mass surveillance database, right? Something that swept in all the content in a non-targeted way. There was also the allegation that AT&T had turned over its call records database named Daytona, even in that very early complaint, right? So the idea that there was a call records program going was around since that complaint was filed in February 2006. And later that summer, USA Today first reported that pretty much every US domestic carrier, every company that had primary US ownership, was also turning over phone records to the government, right? So a lot of these programs that Snowden described in kind of excruciating, sort of gleeful detail based on these PowerPoint presentations within the NSA, we already had some sense were going from as early as 2006, right? So what happened with all this litigation that was filed, you know, almost a decade ago at this point? Well, in our case, in the ACLU case that were brought against that targeted program, the one the New York Times first reported on, the government challenged our standing. They said basically, we didn't have any evidence that our particular phone calls were the subject of surveillance. We only had this idea that the government was somewhat narrowly targeting communications, and a lot of our communications sort of fell within that category. Therefore, we were being reasonable in changing our communications practices in a way that cost us money and made it harder for us to do our mission of suing the government, right? And they said that's not enough, right? You basically need, hard and fast proof that you were a surveillance target. In order to be able to have standing, in order to be able to prove a real, tangible, concrete injury, in the words of the case law, that should let you into court and make all the statutory and constitutional arguments that what was actually happening was illegal, right? So they're saying we didn't have a right to set foot in court, we didn't have standing, right? But one group actually did have proof that they were surveilled. And they filed, I believe, in April 2006, an Oregon Muslim charity named Al-Haramain had been designated as a foreign terrorist organization under the various sort of statutory schemes that allow the government to freeze the assets of and create kind of transactional embargoes on organizations that the government thinks have links to terrorism. Hamas is kind of high up on that list. You can imagine hundreds and hundreds of others, right? The master designation list looks like a phone book. It's about 550 single-spaced pages right now, right? And if this happens to an organization, they're allowed 30 days to challenge the designation. And Al-Haramain did that, and so if you do that, you get, in response, essentially a pile of documents from the government that purports to justify your designation as a terrorist organization, right? So Al-Haramain's lawyers got 80 pages of documents, roughly, from the government trying to explain why they had been put on this sanctions list. And at the tail end of that 80-page packet was a mysterious document, still stamped top secret in big letters across the top of it, supposedly 3 or 4 pages long, obviously left in by accident, that appeared to be, from its contents, a surveillance record of a phone call between the board of the charity and 2 DC-based American lawyers for the organization, right? So it seemed like the NSA was listening to the most sensitive communications that you could imagine. Attorneys with their clients, attorneys based in the United States, with a US organization, right? Just as we had feared, right? And they had hard and fast proof. They had this document that the government, through its own negligence, had given them, right? It wasn't a case of a whistleblower like Snowden, spiriting it off and handing it to journalists in Hong Kong. It was the government doing it out of its own, out of its own hands, right? So what did the government argue in that case? They couldn't make the kind of subjective standing argument that they made against us. Instead, they said that even though they were to blame for accidentally disclosing this document, even though copies were probably still floating around Saudi Arabia, where the whole packet had been sent to try to figure out, what was going on with the designation, right? Saudi Arabia being where the central office of this global charity was based. That the document itself was still classified properly as top secret, and that it was still qualified as a state secret bit of information under the state secrets privilege that allows the government to try to force information out of discussion in litigation, and therefore that it couldn't be used in litigation, notwithstanding that the court had a paper copy of it in their hands, right? In fact, ultimately, the court said that even the attorney's memories of what was in the document, they claimed to have destroyed all copies that they knew about and filed the one paper copy with the court in Oregon originally. Even the attorney's memories of what was in the document couldn't be used, even if they were typed up in a secure facility on a government computer, as is the norm for handling classified information, right? And a pretty liberal panel in the Ninth Circuit agreed, right? So that took care of Al-Haramain. The case against AT&T was just for damages, and Congress in 2007 passed a retroactive immunity statute that ended up basically killing off that case in its original form. As I mentioned, the government, was very aggressive about arguing standing, but they also did a lot more maneuvering. By the time the ACLU case reached the Court of Appeals after a quick victory in the trial court, the government claimed in January 2007 that it had gone to a judge on this FISA court and gotten an order under the original FISA that allowed them to carry out the targeted program. That had been the first one to reach the newspapers, right? So they said, well, we convinced a judge to issue an order that allows us to intercept any communications where we think that one party, inside or outside of the United States, has some link to terrorism. This didn't seem to fit what the FISA statute allowed, and sure enough, 90 days later, when typically these FISA orders are reviewed by a different FISA judge, because they kind of have to keep getting re-upped every 90 days, it turned out that the orders were overturned. So they found one compliant judge to give them judicial sanction for their NSA warrantless surveillance program. Then when that sanction disappeared, they went to Congress. And eventually, in 2008, after then Senator Obama switched his vote and decided to come out in favor of essentially legislatively authorizing this kind of mass surveillance, Congress passed what was called the FISA Amendments Act, the FAA. And that had a lot of effects. It basically authorized judges to go ahead and issue single orders that allowed for a whole slew of surveillance to take place, not things that were modeled on the kind of standard warrant process where you bring evidence that a particular subject is worthy of surveillance, show it to a judge, and the judge authorizes surveillance against that particular target, but to rather go to the FISA court with a proposal for a whole program of surveillance, saying we want to be able to choose our targets, at our own discretion, based on a broad criteria, like we think anybody involved with terrorism should be someone we should listen to, and the judge can stamp off on that whole broad program of surveillance, right? So it kind of dispenses with the idea of individualized review of targeting, right? And that statute passed in 2008. The ACLU again sued based on that statute. They brought suit on the day it was actually passed, and that case managed to get up to the Supreme Court. And in 2013, by a 5-4 vote, the Supreme Court said the government is right about the standing argument, right? They didn't quite say that you need absolute proof that you were a surveillance target in order to be able to bring suit, but they said that the chilling effect theory wasn't valid, at least where the FISA court was doing some review for compliance with the statute and the Fourth Amendment, which this 2008 statute kind of required on the face of it, and therefore they knocked the cases out of court. Basically, no one, it's thought now, can really effectively bring a challenge based on the chilling effect that the existence of a government surveillance program has if they don't know that they're actually a target, right? So that kind of brings us to where we are now. We have sort of a catch-22 for standing, right? If you don't have direct evidence that you were surveilled, if it's just the fear of an extremely broad program of surveillance, an extremely permissive program of surveillance, even if it's targeted, that is your basis for claiming an injury, you're going to get tossed out of court based on standing because of that ACLU case, Clapper versus Amnesty International. If, on the other hand, you have evidence of surveillance and you try to bring a civil suit for damages or try to join the surveillance program and get it declared illegal, the evidence is going to get tossed out of court as being still secret, unless the government decides it wants the challenge to go forward, right? So that pretty much only leaves cases where the government tries to bring evidence that is garnered through this sort of surveillance into the criminal process. The government said as much in the Supreme Court argument in Clapper. They said, look, you guys don't need to reach this issue now because eventually a criminal case will come up where we use the 2008 statute to get evidence against somebody. Some evidence might be fruits of that surveillance of electronic surveillance under the statute, and it'll get into court and the defendant will challenge it and it'll come up into the court system that way, right? It turned out several months after the argument that the Solicitor General had to modify what he had said to the court because it turned out that if the government used surveillance under the statute to lead to other evidence, they never routinely disclosed that that other evidence was the fruits of initial surveillance under the 2008 statute. So in fact, their practices in criminal cases were preventing these issues from ever reaching the courts through the criminal process as well. So again, it kind of closes the circle on this catch-22. We've got a situation where the only time cases will go forward is when the government decides that the proof of surveillance that someone has somehow gotten is something that they're willing to acknowledge as authentic, which is exactly what happened with the phone records program. A few days after those documents were published, the government put its own redacted versions up online and acknowledged that they were authentic. So what exactly is happening now in terms of surveillance? I want to turn a little bit to talk about kind of what we know from Snowden and what, if anything, has changed, right? That pattern that I described of kind of the futility of bringing legal challenges is matched by something else, which is that the asserted authority for surveillance practices has changed rapidly, although the surveillance practices themselves have not really changed at all, right? So right after 9/11, it seemed like the mass of these bulk surveillance programs were actually authorized by a single memo out of the Office of Legal Counsel that purported to provide legal authority for it. That memo was shielded from the usual process of review within the government by some sort of disingenuous use of security clearances that only allowed a few high-level cleared lawyers to review it and barred a whole bunch of other high-level cleared lawyers from even looking at it, right? By 2004, Jack Goldsmith and Jim Comey had managed to take a look at those memos and decided that they weren't valid. So the administration switched to using something called national security letters to do a lot of its metadata program. When the New York Times broke the story in 2005, as I said, the government initially went to the FISA court to try to get authority for it under the old statute, then went to Congress to try to broaden the statutes that governed international intelligence surveillance, and eventually did get it in 2008, right? So you see a process not only of effectively fighting off all the litigation on various technicalities in federal court, but also the legal authorities for the surveillance shifting over and over and over again, right? Which is a process I think we can probably expect to see continue, right? And to some extent, this shifting legal authority pattern may explain why we've seen so many different programs disclosed in the documents that have come out of Snowden's trove, right? PRISM, Blarney, Transient Verbal, Evil Olive, all these little code names that seem like, someone is developing the next hot app within NSA. I think one aspect of that is sort of ever slightly shifting legal justifications for these broad surveillance programs that go by those code names within the agency. Right? So it becomes very, very confusing to try to follow all these things, just especially given their sort of the great number of documents that have come out of this book. So I want to kind of simplify talking about what's actually happening on the surveillance front by breaking it down into two main categories: content surveillance and non-content surveillance, or surveillance of metadata, data about content data, essentially, right? They're roughly the equivalent to the contents of the letter and what's written on the outside of the envelope, right? So let's start with content. I only want to say three general things about it, right? First of all, I think in terms of the scope of content surveillance, General Alexander, the head of the NSA, said that our goal is to collect everything. And I think that's pretty much what they've always been trying to do, right? The PRISM program, that was one of the first programs to be reported on out of the Snowden trove, indicated that NSA was collecting content data right off the servers of just about every consumer IT company you can think of: Google, Facebook, Apple, Microsoft, YouTube, Skype, right? For data in transit, there also seems to be programs that basically aim to collect everything. Blarney was the first one that was reported on, right? So it seems like there are active programs that are doing exactly what that AT&T whistleblower Mark Klein reported on back in 2006, right? And the question we always used to get about this when we talk about it 10 years ago was, is it really feasible for the government to intercept everything? Is it really feasible for them to store everything? And the answer is, basically quite simply yes. To store the contents of all the phone calls from and to everybody in the United States would require about 300,000 terabytes every year. Your typical backup drive that you use for all your data probably has 1 or 2 terabytes on it, right? So the overall hardware cost of that is maybe only about $20 million, right? And really, it's kind of pennies, a drop in the bucket for the NSA and CIA's overall kind of $40 billion budget, roughly, right? We know that they're building a massive storage system out in Utah that's probably capable of doing much more storage than this, right? So when an FBI agent gets on CNN right after the Boston Marathon bombings and says that they'll be able to go back and listen to calls that the older brother Tsarnaev made to his wife before the bombing, he may not be blowing smoke, right? It may be the case that they're able to store all of this stuff, right? So that's point number one. They are trying probably to store everything, right? Second, lawyers aren't immune. So what do I mean by that? Well, when the Supreme Court extended the warrant requirement to the content of phone calls back in 1967, it was kind of a novel thing, because a typical warrant was for a search warrant for a physical space, right? And it was very specific. It met what's called the particularity requirement in the Fourth Amendment. You, the government, are allowed to search within a drawer in this person's desk for a particular type of murder weapon, right? So to extend that to the phone context was very difficult, because a typical phone tap was on a line. It could be used by many different people, including both the target of your criminal investigation and a whole bunch of other people. They may talk to someone who's a co-conspirator, or they may talk to a dozen people who aren't. And there may be privileged conversations, right? Calls with their doctor, calls with their lawyer, who knows what, right? So because a wiretap is so much more inherently intrusive than a physical search warrant, the Supreme Court put in place what are called minimization requirements, right? The case that was decided actually a little before that Katz decision that extended the warrant requirement to phone calls. A case called Berger versus New York. The courts specifically mentioned all these problems and said, we're going to mandate that wiretaps be authorized by sort of a super warrant, something even that requires more effort on the part of the government than a regular search warrant. So you can only use this kind of wiretap authority for very serious crimes. It has to have time limits and be re-reviewed by the courts. You have to prove as a government why no other method of intelligence gathering will work for your purpose. And most importantly here, communications that don't have anything to do with the cause for why you're surveilling the person have to be minimized out. Not surveilled if possible, not recorded for certain. And that this clearly includes attorney-client communications, right? Now, we always thought this applied to international wiretaps as well as domestic ones, right? So when the government came into court and said, well, your argument that you should have standing based on your fears of surveillance under the program the New York Times disclosed is bogus, because you should have been just as afraid that we had warrants from a court under FISA on your clients. We said, no, no, no. If you went about a court warrant, that would have included minimization procedures, and that would have protected our conversations, because our conversations were all attorney to client, attorney to witness. They're all protected by various legal privileges, work product or attorney client, right? And the government never responded to this argument in the litigation, which we always thought was sort of strange, right? And now we know why. The fourth document that was published from the Snowden trove was a Justice Department memo outlining minimization procedures. And it showed had Eric Holder's signature on it, right? Not General Alexander's. And it said basically that their view was there's only a need to minimize out attorney-client conversations when the client is actually under indictment within the United States. So what does that exclude? It excludes talking to family or fact expert witnesses in any Guantanamo habeas case, right? Because those are not, those don't fit narrowly within that guideline. Nobody at Gitmo is under indictment in the United States. But there'd be FISA warrants on meeting rooms in Guantanamo. They're not located in the US, they're not charged in the US, even if they're charged by military commission, right? So those communications wouldn't have to be minimized out. If the government went to a FISA judge and said, give me the authority to set up a program surveilling any communications of anybody with someone suspected of being in Al-Qaeda, that would cover the whole gamut of people down in Gitmo potentially, right? Our attorney-client communications with people like Julian Assange, who are located overseas, but may or may not be indicted yet inside the United States, potentially fits within this minimization guideline as well, right? So a huge chilling effect that this potentially casts on attorneys, right? Putting to one side the chilling effect that this kind of bulk content surveillance has on citizens generally, right? I mean, arguably, this kind of surveillance is completely incompatible with democratic self-governance, right? One of the most kind of remarkable lines that came out on the first day stories was actually from a government source, not from Snowden, a government source telling the Washington Post reporters that we can literally see your ideas form as you type, right? That they had the ability to intercept kind of live synchronous communications on chat and that kind of thing in that level of detail, and the implication was that it's sort of searchable, right? Well, I think when you look back at a lot of things in our original Constitution, including, for instance, the protection for property rights, the reason the founders wanted that in there is that they thought that private property was a bulwark against government control of every aspect of our lives. And if you're going to have a democracy, right, a word that's not really written in the Constitution but is implicit everywhere, if you're going to have a democracy, you have to have people who are independent from the government, who can form their own ideas about what the government should and shouldn't be doing in order to be able to control their government, right? If the government can see your ideas form as you type, you don't have that autonomy to be able to control it, right? And that, in terms of the chilling effect on the public at large, is probably the most dangerous thing about this mass content surveillance. I think the nicest way I've ever heard it put is a fellow Mayor Hawk on Twitter saying, is there a more chilling message to conform that America is not interested in spying on ordinary people, right? Mass surveillance like this gives you a huge incentive to make yourself ordinary, to become conformist in your expression of beliefs on political issues, right, across the board. So, a huge chilling effect on lawyers, but also on the citizenry. And my third point about content surveillance like this is that the fact that it's feasible to gather everything doesn't mean that it's effective at preempting terrorism, which is always the big sell that we hear, right? The problem is essentially what's referred to as the haystack problem, right? The more data you collect, the more chaff there will be hiding those very, very rare occasional kernels of wheat of communication with someone who is actually plotting a terrorist act, right? General Alexander's response to this in testifying to Congress after the Snowden revelations was the haystack to find the needle, which maybe only proves that the actual meaning of farm metaphors is lost on high-tech bureaucrats. But this mentality of collecting everything for its own sake seems to be really well ingrained. It's as if, as Ben Weisner, your last week's guest said, it's as if the NSA thinks we need to build a haystack just in case someone decides to drop a needle into it, right? And in fact, the reporting on the efficacy of those original targeted programs back in 2006 indicated that exactly this was happening. In January of 2006, the New York Times reported that, having talked to a lot of FBI agents who were getting mountains of leads in the form of phone numbers of a suspect from the NSA, said that they used to respond to getting these piles of 1,000 phone numbers by saying, oh great, more calls to Pizza Hut, meaning that they were getting, sort of dead leads, the bum leads in the Glengarry, Glen Ross sense, right, from the NSA. And unfortunately, I think, when we talk about this idea of a balance between security and liberty, and that kind of metaphor comes out all the time in the context of surveillance debates, there's always this presumption that we're dealing with a straight trade-off. No matter how much privacy we give up, we're always getting some marginal, incremental boost in security. And this, I think, is a nice example of how that's not always the case. It may actually be counterproductive to gather more information and to do it in a very broad brush fashion, right? We think about the warrant process where the government is forced to go to a judge with evidence justifying your surveillance and gets a warrant that has these narrow, sort of particularized restrictions as being a whole bunch of technicalities, right? From watching all these 1970s crime dramas where the evidence against the guilty party is thrown out, we think this is kind of something that we put in there to hamstring law enforcement. But it's very easy to think about it as a form of supervision that makes sure that law enforcement works efficiently, right? If law enforcement has to go to a court and prove that there's a reason to actually surveil someone before they implement surveillance, it is a way of making sure that law enforcement focuses on the threats that are real, rather than focusing on building this magnificent technical accomplishment of a gigantic haystack that no one can effectively sort of pour through, right? In point of fact, we have a long history of warrantless surveillance before 1967. Inefficiency in the kind of profiling mode, the idea that law enforcement followed its prejudices rather than actual leads, has been the hallmark of it over and over again. The Church Committee found in the wake of the Watergate era that Nixon and Johnson had both targeted surveillance against their political opponents, the Civil Rights Movement, the anti-Vietnam movement, and duplication, waste, and inertia, in the words of the report, were the primary results of free license allowed in the warrantless surveillance context. Right? So that's all I want to say about content. About metadata, it's interesting. One of the things you hear about metadata is that it is actually somewhat more useful than content to the government, because content people have to listen to. Some human being essentially has to process it, sit and listen to the phone call, read the email, even if there's some filtering that goes on automatically, right? But metadata allows us to sort of graph out connections between individuals, right? So if I know everybody that you're calling, and I know some suspects' calling patterns, I can find other people, right? If you draw a social graph of connections between the 254 most prominent people in Boston in the 1770s, they lead to the most centered person being Paul Revere, according to one study, right? So this allows the government to kind of run around and essentially use automated systems to find suspects in a way that might be a little more efficient than getting the content of communications, right? Your phone records and numbers you dialed and when you talk to people may be actually more useful than the contents of the communications in that sense, because it is more machine searchable, right? Now, that may explain a little bit about why this phone records program got so much attention, right? And I think part of the outrage around it was the idea that there was an order from the FISA court, right, the secretive court, where the government is the only party that gets to go in and make its case, right, where the judges are appointed by the Chief Justice, Rehnquist and then Roberts, right, a whole bunch of conservatives, of the district court judges who were assigned to the FISA court. And, the orders that come out of it, the order that justified the phone records program came from Section 215 of the Patriot Act. This is, excuse me, what was always called the library records provision of the Patriot Act, right? It was so broadly written, allowing government to essentially get a court order to grab huge quantities of business records that people thought you could go to a public library and find out what books everybody had been reading, right? And so, it was one of the first times a major Patriot Act provision actually had been used by the government post 9/11 and was up for challenge, right? But all this attention to the activities of the FISA court, to the Patriot Act, obscured a really important thing about metadata collection, which is that the government doesn't even need a court order to get metadata, right? In 1978, the Supreme Court, in a case about a pen register, device that records all the phone numbers that a particular line is making, said that there's a distinction between going after the contents of the phone call, which requires a traditional warrant under the Wiretap Act, and just getting the metadata about those phone calls on that line, right? The numbers that someone calls and when the calls are and how long they last, right? The court made kind of an untenable distinction. It was highly criticized even at the time that you're turning over the number you dial to the phone company for their use in billing and routing your call in a way that you aren't doing with the content of the communication. But the upshot of it is that this doctrine, which is called the third-party doctrine, when you turn over information to a third party like a business, a telecommunications provider, Amazon, you are renouncing your Fourth Amendment privacy interest in it, and the government can then go and, with a simple subpoena, grab that information from the third party, right? This has been extended by the Justice Department in various arguments to just about anything you share with the corporate service provider. So not just your phone records, but your banking transaction records, where and when you use your credit cards, your web surfing habits, potentially even information that you leave in cloud storage or drafts of your email that you leave on your Gmail account, right? And obviously nowadays, private companies accumulate huge stores of information on us as individuals in order to be able to sell us more stuff, right? When you use your rewards card at the Wayne Reed or the Walgreens, the reason they're giving you a 5 or 10% discount on your overall purchases is so that they can create an identity linked to that card and figure out how to send you stuff to get you to buy more things and walk into Walgreens, right? So, you know, there's an awful lot that you can tell about someone for metadata. In the interest of time, I'll sort of skip over a little bit of this, but you've probably read a lot of the stories that say how easy it is to figure out whether someone is gay, for instance, based on you know, various kind of easily accessible metadata that one can pull off of you know, any number of social networking sites or even your communications patterns on the phone, right? You know, it has a lot of the same chilling effect. I think one of the things that happened, you know, was unfortunate that happened with the Snowden revelations is that they came about 2 months after a scandal involving Eric Holder getting orders to seize the phone records of about 20 AP reporters in connection with a leak into the I believe the botched investigation of Robert Torricelli. And so, you know, again, the chilling effect that metadata surveillance would have on sensitive communications like those of reporters or lawyers is something I think that is especially worrisome, right? If the government can seize the records of everybody that you talk to around the time that a story that you published involving a government leak happened, it's not going to be too hard for them to figure out who you did and didn't talk to within the government, right? Now, all this is not to say that metadata surveillance is effective. There were 2 executive panels convened after Snowden that you know, essentially concluded that the program wasn't worth the cost, didn't really produce any significant leads against terrorist activity, and one very conservative federal judge who found the same in the litigation, right? But I suspect one reason the government wants to create these massive databases is essentially to be able to test its algorithms. I talked about that example of the person who calls in the middle of the night from Afghanistan and then, you know, issues 10 calls out to other people within the next hour, right? The only way you're going to be able to figure out whether that sort of algorithm is effective at picking out the terrorist plotters from the person spreading news of a wedding is to be able to take a terrorist attack that already happened, go back to your database, and test 50 or 100 different algorithms to see which ones only pick out those attacks, right? And, you know, my long-standing suspicion has been that, that part of this is basically tied into the intelligence agency's long-term dream of kind of replacing human intelligence in large part with machine intelligence, you know? You know, human sources are flaky, expensive, prone to work for both sides, and you know, a movie like The Manchurian Candidate kind of, you know, discloses that you know, a long-term dream has been to kind of create a perfect kind of mechanical intelligence agent that won't do all those nasty things, right? You know, the allure of big data is sort of everywhere in our society today, but I suspect it seemed like you know, a very ready solution to the problems, challenges faced by the intelligence agencies in, you know, picking out the very, very rare sort of you know, terrorist sleeper cell plotter, especially in a situation where we had so little in the way of human intelligence resources on the ground after 9/11, right? So. You know, that kind of brings me to kind of summarize where we are right now, right? So even though the USA Freedom Act has kind of shut down the Section 215 authority, the authority under the Patriot Act for the phone records program, and even though the program, as it was understood based on those Snowden disclosures, supposedly ended around Thanksgiving of last year, there's no problem that the government would have basically going with one of these massive subpoenas, some of them authorized by statute to be very broad, and seizing phone records from the phone companies in large quantities based on this third-party doctrine. This idea that it's just like those phone records in the 1978 Supreme Court case, right? It's not content, and therefore we don't have any Fourth Amendment privacy interest in it. The government can just get it by demand letter, right? And ironically, the USA Freedom Act, by eliminating the best understood authority for such collection, court orders under Section 215, may actually make it less likely that a good case challenging the third-party doctrine itself reaches the Supreme Court, right? We have justices as diverse as Alito and Sotomayor in the context of kind of cell phone tracking in the Jones, and I think Jones versus the United States a couple terms ago. I've indicated great skepticism about the broad applicability of the third-party doctrine to all these other things that the government says it applies to: web surfing, location data, you name it, right? And so the fact that the USA Freedom Act has eliminated the best understood means by which the government seizes phone records may mean that it'll actually be a couple more years before a good case gets up to the Supreme Court. Particularly, a good case in the sense of a case where the surveillance practices seemingly affected everybody, because you can look at the kind of detailed polling data on whether Americans care about surveillance all the way back to 9/11, and it's very consistent. What it shows is that when Americans believe that the surveillance is either targeted at terrorists or targeted at foreigners, they don't care at all about it. But if they feel it touches their own communications, even in the slightest degree, in this kind of metadata sense rather than content, they're furious about it. And you see this in the kind of reaction to the Total Information Awareness Program that John Poindexter had been developing circa 2003, 2004. A very similar kind of bulk surveillance analysis program, right? Congress actually defunded that when the newspapers reported that it existed. So, it's not the case that Americans don't care about it. But when you get something like the phone records program that Snowden revealed, that clearly applies to pretty much any customer of an American telecom company, it has the potential to create sort of political outrage that will certainly be reflected in the seriousness with which the Supreme Court would regard that, right? I think in some ways it's ironic that the USA Freedom Act probably took one of the few areas where we had the ability to get a good court challenge going off of the table. And again, those cases might have been all Haramade. The government might have come in and said the Snowden documents were leaked. They're even worse than those documents we accidentally disclosed on our own in al Haramade. They should still be regarded as secret, and you can't litigate them as if they are out in the open, even though everyone around the world has seen them, right? That brings me to my conclusion. Hopefully we'll have about 10 minutes for questions here. But, to sum up, it seems like along with everything else, attorney-client communications are probably being surveilled, and that chilling effect risks turning us all into government-controlled conformists, and the courts are not going to save us. That's the one-sentence version of all of this, right? And despite the fact that some Republican debaters were up in arms about the USA Freedom Act, going after Rubio about it, the main legislative outcome seems to have been to have forestalled what would have been one of the better challenges that may have allowed some significant limits on the government's ability to grab the records in the hands of businesses, including telecom providers, just with a subpoena without even going to a court, right? We shouldn't underestimate the symbolic value of Congress finally pushing back, the first law actually cutting back the scope of surveillance since the Watergate era, really. But the current state of affairs is largely depressing, especially in light of the floodlight shown on these issues by Snowden, right, at great personal risk. Right? But I want to end on the one optimistic note, which is that for all of this sort of pessimistic news about the courts and Congress and the reality of mass surveillance right now, the most important battle in the surveillance wars was actually won years ago without anywhere near this level of public scrutiny. Right? During Clinton's second term, there was a debate about whether to restrict the creation, dissemination, export of encryption technology, and the administration lost. that battle. And for all of its technical prowess, until the NSA can change the laws of physics, it won't be able to defeat relatively simple encryption programs that are available for free all over the web, right? And even as cautious a figure as Snowden says so, right? He said in a chat session that the Guardian did with him shortly after his disclosures, encryption works. Properly implemented strong crypto systems are one of the few things that you can rely on, right? Now, the problem with encryption is that it typically is 2 steps more inconvenient than just pressing one button and having Skype install on your system. But the people who are writing this software in the open source community are aware of this. And so right now, even though email is sort of inherently vulnerable, there's no way to shield the metadata from scrutiny. As it passes through the web, there is a free Chrome and Firefox browser extension called Mailload that can encrypt the body of your Gmail. It's quite easy to use. There's a simple program called Off the Record Messenger that can do even better for Google Chat. With chat, it's possible to essentially not leave a metadata trail, and so the hackers who work on this, writing this code, all communicate with each other using sort of synchronous communication rather than email, chat rather than email. And OTR is a fantastic program for doing that. Works for multiple-way chat as well as two-way. And there's an iPhone Android app called Signal that you can get from the Apple Store that allows for encrypted voice calls and messaging through your phone to any of your other contacts who've installed it. Now, if your phone is vulnerable, the way your computer might be with like a keystroke recorder or some other malware, it's not necessarily going to help you, but it's about as solid as an app that you can install with a push of a button for free can get on your iPhone, right? So even if you're not worried, like we are, about our communications being a special object of government interest, by using these programs, you can ensure that the mere fact of encryption won't make it easier for the NSA to flag communications of people who have a need to use encryption like we do. Privacy hawks and activists, right? And you can send a stronger message to the NSA than the passage of the USA Freedom Act or anything like it ever would, right? So, if the lesson of the last 2 years, and indeed the last 14 years since 9/11 is clear, stop waiting for the courts and Congress to save you. I think the corollary lesson is, start engaging in self-help by using encryption. With that,